Okay, at 6:30, I'm going to call the meeting to order. And Renee, can I have a roll call?
Mr. Parker, Ms. McCowan,
Here.
Mr. McDaniel,
Here.
Ms. Byrd,
Here?
Mr. McClure, Mr. Axton, Mr. Jablonski.
Here.
We have a quorum.
Moving to our consent items, item number 1, consideration of approval, rejection, amendment, and/or postponement of the minutes of the June 9th, 2022 regular Planning Commission meeting.
That's all.
Okay, it's all consent?
No,
No, right?
the minutes is all that's on consent.
Okay, that's all. Yeah, all right. Does any member of commission wish to remove any item from the consent docket? Does any member of audience wish to remove any item from the consent docket? Take a motion to approve
Move to approve.
and a second
Second.
and a vote.
You may vote. Everyone has voted, and the motion carried 4-0.
Okay, moving to non-consent items, going to items 2 and 3. These look to be together. I understand they're being withdrawn, though. Postponed, okay. I'm going to read these through, but they will be for a postponement. Consideration of adoption, rejection, amendment, and/or postponement of resolution number R2223-6, Rental Ranch 2 LLC and DL Hayes Co., Inc., request amendment of the Norman 2025 Land Use and Transportation Plan from low-density residential designation to commercial designation for the east 20 feet of Lot 50 and all of Lot 51, Block 2, Woods Lawn Addition, located at 621 Highland Parkway. Item number 3, consideration of adoption, rejection, amendment, and/or postponement of ordinance number O-2223-2, Rental Ranch 2 LLC and DL Hayes Co., Inc. request rezoning from R1 Single Family Dwelling District and C2 General Commercial District to SPUD Simple Planned Unit Development for the east 20 feet of Lot 50 and all of Lot 51, Block 2, and the west 25 feet of Block 9, Woods Lawn Addition, generally located at 621 Highland Parkway. And the applicant has requested a postponement. Do we need a vote on that? Mm-hmm. So I would, unless there's any discussion to have on that item, I would take a motion to postpone, to approve a postponement.
Move to approve what you just said.
Second.
And a vote to postpone.
Can we have a discussion? Actually, I have a question.
Sure.
We're about to vote on an ordinance change that doesn't allow so many postponements, and they've already postponed. This will be the second time at least, right?
No.
It's different postponements. It's not at planning commission, it's at city council.
I was going to ask that if the new rule is only for city council. Okay. Just curious. Thank you.
Okay, you may vote. Everyone has voted. Carried 4-0.
Moving to items 4 and 5, zoning ordinance amendments. Item 4, consideration of adoption, rejection, amendment, and/or postponement of ordinance number O-2223-1, an ordinance of the Council of the City of Norman, Oklahoma, amending Section 429.1 Flood Hazard District of Zoning Ordinance, subsection 1, to add citation to Oklahoma statutory authority for local regulation and providing for the severability thereof. We're going to read this one as a separate item from item 5. So we're just looking at item 4 to start. And I would take a staff presentation.
All right, I'm Jason Murphy, Stormwater Program Manager for City of Norman. Floodplain ordinance revision. Our floodplain ordinance was originally adopted in 1975. It's been revised 14 times for various reasons over the years. We adopted the floodplain ordinance initially as to be able to participate in the National Flood Insurance Program. And the NFIP enables homeowners, businesses, renters, et cetera, to receive federally backed flood insurance. And it also provides the ability to qualify for disaster relief funds as well as certain grants, things like HMGP grants, things like that. FEMA is who administers that program. And back in April, we had a FEMA community assistance visit where they came in, they kind of review everything that we do as far as floodplain administration, look through permits, et cetera. And one of the things that they noted that we were missing was in our floodplain ordinance, there wasn't a very specific call out to the state statute that gave us the authority to administer the floodplain. How we've missed it all these years, nobody knew. It just hasn't been in there. It was assumed and wasn't. So the update to the ordinance is to just add that very specific language calling out the state statute that gave us that authority. It is not a new state statute or anything like that. Our ordinance revision timeline, we've already run it through the OWRB and the Floodplain Permit Committee on June 6th. And here we are now. If it passes tonight, we'll take it to council in August, and then hopefully we'll adopt it in October. Here's a copy of the floodplain ordinance revision. The changes are marked in red. And like I said, all it's doing is calling out the specific state statute in section 1601 and 1620 that gives us the right to administer regulations in the floodplain. That is literally all that's changing right there. And besides that, any questions or comments?
Any questions for staff? Any audience comments on this one? Okay. Any discussion? Then I would take a motion to approve,
Move to approve.
and if someone would second,
I'll second.
and a vote.
You may vote. Everyone has voted, and 4-0.
Moving to item 5, consideration of adoption, rejection, amendment, and/or postponement of ordinance number O-2223-4, an ordinance of the Council of the City of Norman, Oklahoma, amending Section 22420, Planned Unit Developments, and Section 22442.1 amendments, both within Chapter 22 zoning ordinance of the Code of the City of Norman to establish a postponement policy concerning certain development applications presented to City Council for consideration or postponement, and providing for the severability thereof. I am ready for your presentation.
Good evening, Commissioners. I am Beth Muckala with the City Attorney's Office, and I am here to present this amendment to the zoning ordinance. In April, the City Council Oversight Committee reached out to staff with questions regarding efficiently moving applications through the development process. Namely, we were seeing repeated requests for postponement, usually at the final consideration stage when they came before City Council, and there were concerns that that disrupted non-applicant interested parties in their responses, basically, to the development applications. So in May, a draft was taken back to the Oversight Committee, and the recommendation was to go ahead and start moving this through the process. And so this was the first available agenda. And so all zoning amendments come through here. So what you see in your packet is amendments, very small in nature, to 2 sections of the zoning ordinance. First, to section 442.1, which is the main amendment, and that is to the section concerning amendments to the zoning ordinance. And this is going to include amendments to language, amendments to zoning districts in particular, because that is going to catch the applications that are changing from, let's say, residential to commercial, or from any zoning district to planned unit development or simple planned unit development. And then there's also a tiny tweak suggested to 22, section 420, simply for purposes of clarification and consistency. We did not see a need to add similar language in the SPUD section. It seemed to be self-clarifying. So what this language does is essentially formally put forward a policy on postponements when they come before City Council. So it would not address what happens here at Planning Commission. Right now, it's only stating what happens at the City Council stage. And what it does is it kind of sets a new tone. Before, when applicants were before pretty much any tribunal in Norman, they were given the authority over their application. And so when postponements came, there was this informal policy of deferring to applicants on their need for those postponements. Out of concern for non-applicant residents that were interested, and also just in the interest of keeping these applications moving efficiently through the system, this was the solution. To first say that absent, barring unique or extenuating circumstances, they will, as they have in the past, generally be given that first requested postponement. But after that, the policy makes it very clear, discretion will be exercised. And so applicants are now on notice by virtue of this formal statement of the policy that effectively they get one postponement as long as there aren't circumstances that would make that unfeasible on its own. So that's really the sum total of the change here. Does anyone have any questions?
No, I was going to ask, apparently we're adding this because this has been an issue. Would that be correct?
Yes. Now, and I think I said this in the staff report, but the authority to say no exists with every tribunal, just as it does with city council. This was really done in an interest to make this shift in policy crystal clear and to put it out there and allow applicants going forward to know things will not be proceeding as they have in the past. But yes, it was definitely in response to what was perceived as, I would say, a lot of postponements on the same application that would tend to widen that window of consideration to the point where you might be aware of this, but there's a certain period of time where the notice that's sent out, the notice list to residents that are surrounding, there's a certain period of time that that's good for. But by the time you've gotten to city council, you're no longer held by that standard. And so theoretically, with indefinite postponements, it could really go on a long time and ownership could change, even though technically the notice provisions are complied with. So there's a lot of practical considerations going into this. And as I said, right now, this is only to deal with the issue that's been observed, and so it only really addresses city council. If there are shifts or changes in applicant behavior in response to this that affect other commissions such as your own here, we can evaluate the need for that in the future. But right now, it's definitely targeted to address the issue seen.
So I have a couple questions. Do we have any kind of definitive language as to what unique and extenuating circumstances are anywhere within the ordinances?
No, there's no definition as to that. It would be as other language is in our ordinance, which is not uncommon to have terms such as reasonable or typical, usual, those types of things. What it really does is make it clear that city council will need to evaluate and present their evaluation, and like any other decision, have a basis for it. It essentially provides that basis. And that language really was necessary to make certain that a policy would not be adopted that required postponement when unique or extenuating circumstances existed. So it would go case by case.
And then my other question, since you mentioned about the notice requirements currently are within date of application, or is it within date of being heard by city council? Which one is the time frame based on for notice to public?
Okay, so actually our notice requirements are geared backwards from this meeting. We're required, what's the number we're required?
20, I think it's 20.
Right, but we close the application period 30 days prior, is that it?
It's more than usually.
To make sure everything gets turned in. So it's really 6 months that list is good from that date. So it's closer tied to application. It doesn't date back from city council, which is why we could get in the situation where with multiple postponements, that list could technically be inaccurate, even though it's compliant with that notice rule.
Has that come up previously for discussion about having new notices delivered as, maybe as part of being able to be heard by city council? It's being monitored that notice has been given within the last 6 months?
I am not aware of a discussion in that regard, and I would want to think about really the implications of something like that, because the notice being at the beginning of the application really does do a lot to aid in how efficiently it moves through the process. If multiple notices were required, we could be dealing with new owners that, are coming in at the very end of the process. And even though we're complying with every notice under state law, we might be creating a situation where we might actually be putting people in to disrupt the process. So, I mean, it might make things harder to do that. Although, if they let the 6 months expire, they are required to redo it. We haven't had a situation where they're required to redo it. Right. If they've made it through planning commission, then they are fine. I just mean if before they get to that point, there have been applicants that need to redo the notice.
So to make sure I understand, the applicant has to, within 6 months, have notice. They usually get their list. They deliver notice. They get that return for mail. They have 6 months to then get it in front of planning commission, but it could go beyond 6 months before seeing it city council. Is that correct?
That could
Yes.
happen.
Okay, thanks. Just looking for clarity on that. What about risk for standard of practice? If we have a council that, for example, in their discretion is regularly approving a lot of postponements for one applicant, but maybe doesn't grant them, I mean, maybe they regularly continue to, in their discretion, typically grant postponements, and then they have one applicant that comes through and they don't grant the postponement. What kind of risk does that put for us in the city with that standard of practice?
You're absolutely right that when you have a discretionary standard, you are always going to have a risk for someone claiming unequal application of those terms. I would not say that this amendment actually increases that in any way because, again, the discretion is already there. And actually what this does is more move in the direction of solidifying the fact that they are very likely to get the first postponement, even though technically under the previous standard, they were not guaranteed it, even though the policy normally gave it to them. So in a way, it actually is moving more toward a non-discretionary standard, at least on the first.
Okay.
Just one more question. It states in here to a date certain, so it doesn't have to be the next meeting. They could ask for an extended period of time if it's a issue or a problem they're trying to work through with possibly someone who has, protested against the project. Is that fair?
Exactly. It
Okay.
encourages planning. You're working through issues.
Okay. I don't have any more questions. I believe there was a comment that came up, but do we have any more questions of staff? Okay. Seeing none, do we have any public comment? Yeah. Come on up. And please state your name and address for the record.
So, good evening, Commissioners. I'm Lee Hall, and I'm pleased to have the opportunity to speak to you tonight as a resident of Ward 4, and as the most recent chair of the Oversight Committee,
And your address.
648 South Lahoma. The Oversight Committee recognized that multiple postponements, as mentioned by our very able legal staff, by applicants may place an undue burden on non-applicant residents that are impacted by proposed development. The committee also recognized the need to promote an efficient consideration of applications and that repeated delays at the council level are really not beneficial for the applicant or the community. This policy, if adopted, should also encourage more investment of time at the pre-development meeting and also at the Planning Commission meeting to address any needed changes to the proposal and promote collaboration early with the goal of reducing confrontation by the time that the applicant comes before the city council. So as, recently reviewing so many of these applications and these requests for postponement, by the time the application reaches the city council, the project should not require repeated postponements. The work to improve the quality of the project should have already taken place. And so one of the reasons I really wanted to come speak to you tonight is to make sure that you all understand that the council has great respect for the work of the Planning Commission. And I would like to encourage the commission to use the time when you are reviewing an application to apply your areas of expertise, because you all have much more expertise in areas of development than the council does as a whole. And as you review these applications, if the proposal needs further improvements, if it needs changes of any kind, or further mediation because of neighborhood conflicts, I want you to remember that the commission has the authority to not only approve or reject a proposal, but you can also postpone a project for further review. You can also recommend approval conditioned on specified modifications that the commission recommends. To this end, this can really expedite the application process, I believe, and result in projects that are ready for swift action at the council level if we invest the time up front to have those projects ready for immediate action instead of the need for constant postponement. So that's why this is before you tonight. So thank you for your consideration.
Thank you. Any other audience comments? I think there was some Planning Commission discussion.
I have a comment, but it's for later. It's in the miscellaneous because it's about some of the existing language. But I will make a comment on the new part. I think it's smart for exactly the reasons stated, that other people are involved. You know, when residents come and they want to be seen, having to come back 2 or 3 times is kind of unfair, and it would lead to people not participating. So I think it's a smart amendment, and I'm going to support it.
I just have another comment to make about consideration for the applicants too. When we deny an applicant, there is a 1-year waiting period that they are put on hold for, at least at City Council, and I believe that is also true of Planning Commission. So when we say no, we inevitably will be delaying that project for a year. And I think that, I think it's a good reminder that Lee Hall gave us today that we do have some options on there, but being mindful, there are a lot of costs for letting a project sit. I think in general, many of us are in favor of getting projects more streamlined through in the way that they need to be, not having a lot of issues coming up later at City Council. And, I think that was a good comment that we can approve as amended. We can make a postponement, but I would caution postponements and the delays that causes, that we be mindful of the developers also. I think it is important that we're mindful of our citizens and make sure they have a chance to speak, but we also need to be mindful the difference of 1 month can be thousands upon thousands of dollars to a developer. So just something also to be mindful of. All right. Seeing nothing, other comments, I would take a motion to approve.
Move to approve.
Second.
And a vote?
You may vote. Everyone? And the motion carried 4-0.
Okay, moving to miscellaneous comments for, I'll start with staff. Does staff have any information for commission? I did want to make sure everybody had seen that we did receive the resignation from Commissioner Beck, his extended service with the commission. So we do have 2 vacancies as of this time that I am aware of for Planning Commission.
I have a comment, thank you. I was reading section 22442.1, paragraph B, and it reads, in case of a protest against such change signed by owners of 50% or more of the area within a 350 or larger foot radius. And it just seems ambiguous. I'm not sure why it says or larger, and I asked the staff and they explained it to me, but I thought I would just get it on the record, and maybe the staff now or later can also explain it to the council, the ambiguity.
Thank you, Commissioner Jablonski. Yes, the language in Section 4B of 442.1 does reference 350 or larger foot radius, and the or larger language in there has been a subject of questions in the past. It does not say it in this particular portion, but what it has been interpreted historically to relate to is a situation in which the radius has to be expanded. Whenever you have the 350-foot radius, you need to catch at least 15 properties, and when you have large acreages, sometimes that's a challenge. So you may end up at the end of the day with a larger radius, and so that is definitely what it applies to. You just have to kind of search for that answer, and it is awkward language.
Maybe to help Commissioner Jablonski, maybe you could give us the process if something, we had a recommendation for a change to the language, what that would look like. Is that fair?
Sure.
Yeah. All right, so what would the process look like if a commissioner saw language that they wanted to see changed?
So that's a question. Oh,
Yep.
okay, I want to
Yeah.
be sure. A zoning ordinance amendment, like anything else, can fix language. Now, it could be that other language probably needs a little tweaking here and there. So I would say that this is not like an immediate need to address, but making a note that when and if the zoning ordinance is smoothed out in the future, we just think about that and make it just more clarified so that everyone knows that's the situation. We're not going to create larger radiuses out of the blue to apply a different standard. Just make it clear it relates back. So that's something we can note.
Thank you.
Okay. Any other discussion? All right, if there's nothing else to come before the committee,